pull that up. Yeah, so here it's going to be May 2nd is going to be this actual court date if it goes all the way through to that point. It might not. The judge at some point might just say, I've heard enough, we need to move forward, or we don't need to move forward. And we'll kind of see what happens with that. So here they're going to be going through the reasons why they think that this case should not be dismissed. Remember that conversation around the dodgeball and trying to like find the areas of the court. So they're kind of battling out for space in this legal battle of, okay, well, this is where we think we're strong, this is where we think we're weak, and they're kind of battling out and finding those lines. And this is a lot of times why this can be really helpful, because when two people are arguing about something, it's usually not logical. And so when you start doing it in a court of law, you have to start making legal, logical arguments. And so that's why a lot of times these cases will actually be solved before they get into the court, because they're seeing how strong their legal standings are. So as we get into this is, again, WFG's filing of why they think the motion to dismiss should not be granted. And so that's exactly what they're talking about here. Let me get my pen out. And so they're talking about Eric and Sandra together, along with Chernowski, Carter, and Dewan. Thank you for the corrections on how to pronounce that. And this motion should be denied in its entirety to the extent that the court grants the motion or any part thereof. It should be leave to amend. The leave to amend should be permitted. So basically what they're saying is that if first and foremost, the judge should not grant this, but if he does, then allow us to amend certain things. For instance, we'll see, and maybe we should do a drinking game around it. I know it's 9 a.m., but do a drinking game in Eric's filing and see how many times he says 16600, because that's been his argument for everything. But basically they're going to say, well, if you find that part to be accurate, then allow us to mend the other things around whatever you find in our filing to be inaccurate. So if you think one thing's wrong, you shouldn't throw out all 6, you should just throw out that one, allow us to modify the other things. And so that's what they're asking the judge for. So introduction, WFG's brought this action against the defendant to enjoin their ongoing misconduct to harm and unlawfully compete against WFG through their new business, GFI. In violation of their contract obligations and law, defendants entered into the agreement. So this is the agreement you sign when you're a new agent, no matter what company you work with, to become an independent contractor insurance agent with WFG. Their contractual agreement with WFG, and therefore defendants breach various provisions of that contract that they promised not to misuse WFG's confidential information, refrain from disparaging WFG, abstaining from recruiting other WFG insurance agents. Defendants disregarded and breached each of these provisions. In addition to ignoring these reasonable and enforceable covenants, the Olsons engaged in misconduct beyond the agreement that constitute violations of numerous common law torts and California law. To be clear, WFG does not contest WFG's right to compete in the market, if it does so faringly and lawfully. And I think that's been a lot of our talk here has been, okay, it's one thing to start another company, you're allowed to do that, you're allowed to sell insurance, and you're allowed to recruit people, you're allowed to do all these things, if you're doing it in a fair and lawful way. The motion, however, suggests that the only way that GFI can compete is by rating WFG agents and its insurance agents, customers, imitating all aspects of its business structure, disparaging WFG, and targeting insurance agents affiliated with WFG. The operation of WFG and GFI does not have to be a zero-sum game, but defendants have made it so. Meaning, you can go out and start another company, do whatever you want to do, but don't come in and raid the former company. So litigation before this court is a precursor to the prosecution of these claims against the defendant in arbitration, as permitted by the arbitration agreements with WFG, WFG's investigation of the defendant's scheme and wrongdoing, and the current factual landscape of the dispute is constantly evolving. To the extent that WFG has learned critical facts since the filing of the first amended complaint, it should be granted leave to amend, because the first amended complaint pleads viable claims against the Olsons, and the motion must be denied. So they're going to go through this background. And to me, this sounds kind of fair, right? Because, I've had people say, well, people aren't slaves, right? So you don't own people. But same thing when you get married, you go into a contract with somebody and you say you're going to act in a certain manner. You say, I'm not going to do these things against you. This is a partnership. We're going to work together. So it's important to understand that this is kind of where the argument is evolving into. And so they're saying, well, you've kind of broken those agreements. And what Olson is trying to say is, well, we broke those agreements in wanting to start this new company. And okay, kind of fair. But if we look at it in a way that any other kind of competition, maybe we'll talk more about this once we see Olson's side of it. But if I wanted to go start a new company, let's say there's Coca-Cola, and I want to start a new company, you're welcome to go do that. You can start another soda manufacturing company. That's perfectly fine. But how you do it, I think, has implications for your actual intent, and there's a very different way of doing that. There's a difference between, we kind of talked before, if you're married and you cheat on your wife, that's different than if you're married, you get divorced, and then you have another significant person in your life. Same exact, like if you took 1,000-foot view of that, same exact process, but how you go about it is very, very different. So WFG is a company that contracts independent contractors, insurance agents who desire to utilize its platform to run their businesses. When using WFG to run their business, insurance agents also sell fixed insurance products to customers offered through WFG. To engage with WFG, insurance agents must enter into a contract that, among other things, prevents insurance agents from disclosing WFG's confidential information, requires insurance agents to refrain from disparaging WFG, and prevents insurance agents from soliciting other insurance agents within a limited geographical area to leave WFG to join a new competitor. Insurance agents engage with WFG operate in a hierarchy containing an upline and a downline. Olson's were insurance agents engaged with WFG under contractual obligations, became highly successful in his career, had 900 agents. Eric and his wife, who was also in his downline at the time, Sandra, had resigned from WFG and formed GFI a week and a half after her resigning from WFG. She proceeded to register in Wyoming, in California, Texas, and Florida, all the states in which the defendants conducted WFG business, and where his downline insurance agents were primarily located and conducted WFG business. To productively recruit for and build GFI, defendants many while still under contract with WFG took advantage of their agreement with WFG, that is their unique position and access to confidential information, to unlawfully compete. They conspired and employed their anchor leg scheme where one spouse would leave WFG for GFI while the other remained and continued access. We've talked a lot about this, right, with the confidential information. So for me, I was thinking about this in another context, and I kind of brought up the soda idea before, right? So if I'm working for Coca-Cola, and I have access to their client list, I have access to their employees, how much they make. Let's say I'm a high-ranking person at Coca-Cola, and I want to start a new company, PepsiCo, right? There's a difference between my wife going and starting that company and going through the normal process of hiring people and getting clients. What WFG is saying here is, well, you took that inside information, you knew what these accounts were doing, you knew what these people were making, and then you took that information that you only had access to while working for Coca-Cola, and I found these accounts, the highest paying accounts, and then I went and targeted those accounts who were originally Coca-Cola's, and I went to them and I said, hey, I'm with Coca-Cola, but, or maybe I give the information to my wife. My wife goes to them, knows exactly how much they're paying. Let's say they give them, I don't know, one of the largest accounts. I'm just making this up. Let's say it's Hilton. And then my wife goes in there and approaches Hilton and says, hey, I'll save you millions of dollars a year if you come over and get your soda with us. Well, they know how to manufacture it. They know where to do the bottling. They know how to do all of that stuff that they got from the inside information. And where they're kind of trying to draw the lines here is Eric's side is saying, well, yeah, he's worked in the industry long enough, he's built these relationships, and that's fair. right? You would know a bottling company, and you would know where to mix the whatever it is for your soda. But the difference becomes, well, now I know the client's information, and now I start attacking the clients to bring over to my new company. And let's say this Hilton company that I'm selling Coca-Cola to, well, now I'm going to give that to my wife to go approach them. And if I can now approach the person who has that account, let's say he's making, I don't know, $250,000 a year off of that account, well, I'm going to go to him and say, hey, if you bring this account over, I'll give you a little bit more money. Since you're going to pull this huge account over to us, well, that gets our company going a lot faster. And let's say he says yes, well, perfect, now he pulls that. Let's say he says no, and then I go after the client and then bring the client over and then go, well, if you don't come over, you're going to lose that $250,000 a year. This is where it gets into that space of like, is this, whether it's legal or not, is this a proper way of doing business? And a lot of times this gets emotional. And if you're on team GFI, you're going, oh yeah, that's a perfect way to handle business. That's perfectly fine. And if you're team WFG, you're like, no, that's not the right way to do it. Well, I think we need to get away from the team aspect of it and go, well, is this a proper way of handling business or not? Because to me, if I was going to make a decision on where I wanted to be, I would want to know kind of how these things came to place. And so there's a big difference between just going and starting another company and using all your confidential information. I print out the client lists and the employee lists and how much they make, and I leave that on my dining room table for my wife to find, and then she goes and approaches all those people, and then somehow I can say, well, I wasn't a part of any of that. You see what I'm saying? That it really blurs the line of what's actually happening. That's kind of what's going on here. That's what they're talking about with confidential information about other insurance agencies, their hierarchies, their compensation information, business vendor information, all of this stuff. They're working for Coca-Cola, taking this information that they have, approaching the clients, approaching the associates in Coca-Cola to move over to their new company. Now, that's effective in starting a new business. Don't get me wrong, you're going to start off with 10 or 20% of the other company's clients and their employees, but is that a proper way to really start a business? And this is kind of where that argument gets muddled into the middle of it, in being able to build that business through the WFG's platform. Versus if they had started Pepsi and then just went out and found clients and they hired people and they did the normal process of starting a business, those are two entirely different situations. And that's kind of where they're arguing in this middle aspect of that. So perfectly okay to start another company, perfectly okay to hire people, and what they're using is this the code 16600 and saying, well, if you don't allow me to take people in business from Coca-Cola and move it to my wife's company, well, now you're impeding my ability to do business at all. You're saying I'm not allowed to hire anybody, and you're saying I'm not allowed to have any clients. It's a non-compete now. And it's like, no, there's a very, very different set of standards for you just starting another company and you pulling all of this stuff from one company to the other while you're getting paid from one company and starting your other one, right? And so there's this whole gray area in between that GFI is trying to just kind of glaze over. So the defendants replicated this unfair business practice at mass scale, encouraging unknown members of couples at WFG to split themselves between WFG and GFI. So I have employees who are working at Coca-Cola, and then we hire their wife at Pepsi, and they start moving those accounts over to Pepsi. They start moving all this stuff over, and now they're getting paid from one company and getting paid from the other company as they're literally taking stuff from one to the other. And I think if we saw somebody do that, if we took the emotions out of it and we looked at Coca-Cola somebody at Coca-Cola doing that to somebody at Pepsi, we'd go, wow, that's not really a great way to start. I mean, it's a good start for Pepsi, but it's not necessarily a great way to handle business. So it was feasible for both to move to GFI. So they're saying, well, the people in WFG could have just left and gone and worked at GFI. That would be perfectly fine. You're allowed to do that. but that's not what they're choosing to do. Defendants employed tactics such as spreading fraudulent rumors of WFG in order to manipulate WFG's insurance agents into signing their unlawful recruiting efforts and enable their theft of the WFG business. So on top of that, I'm working at Coca-Cola and I go to these accounts and I go, you know what? There's about to be this mass exodus. All of these people are going to leave. You're going to have terrible, like nobody's going to be able to help you do all of this stuff. It's going to get really bad. Just come over to my company and we'll help you do that, right? And so you can kind of understand there's like disparaging things that are being said that may or may not be accurate. So all of this goes into the encompassing aspect of what was the intent behind it. It's not just what was done, it was how and why was it done. So through this process, defendants not only breached their own agreements, but also interfered with the agreements of WFG insurance agents who followed them. So exactly, and this is my biggest concern. Like Eric's going to be fine, right? Like he'll maybe pay a fine or something, but he's going to be perfectly fine. The question is, what happens to the agents that come over and who are straddling the fence between the two companies, especially if they really start getting into, or they were doing some of the things as far as moving clients and that kind of stuff over. It's going to be interesting. So WFG commenced this action and applied for an ex parte temporary restraining order, right? Remember, we're talking about that that preliminary part where we're kind of like fighting for ground against Eric Olson and Sandra Olson before the Superior Courts of California. The Olsons removed this court on January 26. WFG refiled the motion for the temporary restraining order in the court's order. Therefore, the court granted WFG's motions for expedited discovery. So let's start doing some of this discovery early. But then they also said that they were not going to do the temporary restraining order. On February 15th, Eric Olson filed his motion to dismiss, which was joined by Sandra. WFG filed this and added 3 new defendants who conspired. This is where Cherwanowski, Carter, and Dewan, or Cofield got added into that. And so this motion must be denied in full. The legal standing. So in considering a motion to dismiss, all allegations in the complaint must be taken as true and considered in the light of the most favorable to the plaintiff. So they're going to go through some case law here. They're kind of helping the judge go through and say, hey, this is how it's been applied in other areas. And so we'll kind of skip through a little bit of that. As an initial matter, WFG maintains that this dispute is ultimately governed by the mutual agreement and arbitration claims agreement signed by WFG and each of the insurance agents, including each of the defendants. While WFG's position is that it is appropriate for the court to continue to adjudicate this matter for purposes of granting WFG preliminary injunctive relief, WFG reserves its right to argue that the merits of this motion is within the decision-making power of the eventual arbitrator, and that has nothing to do with this opposition should be considered as a waiver of its right to arbitrate. So argument. Defendants have breached 3 separate discrete provisions of the agreements: the non-solicitation clause, the confidentiality provision, and the non-disparaging provision. In an effort to expand the court's narrow ruling of the non-solicitation provision, the Olsons attempt to shoehorn a confidential provision and a non-disparagement provision into the same argument, which the court has rejected. So what Olson's side was saying, and we'll see this here in a little bit, is they're trying to combine all of these things into one. They're saying that the only way to operate a new business is to take people and clients and disparage and take confidential information to start your new company. That's the only possible way that you can start a new company and really have it up and going. And so that's why they should be allowed to do all of this, because that's just simply how you start new companies. Provisions are valid, lawful, and actionable. They're talking about on their own, both provisions are valid, lawful, and actionable. They're talking about the disparaging provision and the confidentiality provision. So they're kind of giving up a little bit of ground here. If you remember, Olson's trying to say that non-solicitation is the same as a non-compete. Very, very different. But they're blurring that line kind of there. And WFG is going, well, okay, that's fine, but that still doesn't give you the right for these other two. These two flat out, even if the judge says, okay, you can take clients and you can take people, you're still not really supposed to take confidential information and disparage the company on your way out. So they're kind of like saying if you're going to get rid of that part, we still want to argue these other ones. Further, while the court found that the non-solicitation may not be applicable post WFG's contract, the covenant is still actionable, and breaches that occurred during the Olsons' engagement with WFG. As such, since many of the defendant's actions occurred prior to separating from WFG, all three provisions are enforceable, and WFG has pled sufficient facts to show that marital breach of the terms of each provision, and they kind of go through some more case law there. Given the validity of the three contract provisions, WFG does not believe that it is necessary for the court to reform any of this through narrow limitations, constructions, as the Olsons suggest. To the extent that the Olsons make arguments based on illogical interpretations of the part of these provisions, does not necessarily preclude Mr. Olson from the contract. They're talking about Olson and the contact with his mom. Their Olson side is trying to say, well, you're saying I'm not supposed to, you're saying in a non-compete or non-solicitation, I'm not allowed to talk to my mom anymore. I was like, well, no, you can still talk to your mom. Even if your mom came with you, that's okay. But that doesn't stop. But that's different than going and saying bad things about a company. It's going to fall apart. All of the leadership is leaving. It's collapsing behind you. If you don't leave, you're going to be stuck with all of this. And so you're better off just moving to somebody else in the team is very, very different than saying you're not allowed to talk to your mom anymore, right? So the court recognizes them as such instead of relying on the reasonable read of the contract, especially at the pleadings of the stage. So obviously, anytime you're going to argue these things, you're going to take it to the full extent on either side. Well, you're saying I'm not allowed to solicit anybody, so that means I can't talk to my mom, right? And so they're taking it to the extreme extent here to make it look like it doesn't make any sense. And then we're going to come in here. I think we should do a drinking game around this. So every time we see 16600, we'll take a shot. I know it's 9 o'clock in the morning, but that could still be fun. So the court already determined that the confidentiality provision not so broad to be void under this particular section because it is tailored to personally identifiable information or confidential information created by or on behalf of belonging to WFG and his exceptions for public information. They're going to go through some more case law and we'll pick this up. The other cases cited for this proposition that the confidentiality provision is void are not at the moment to dismiss stage and are thus evaluated under a different standard, do not evaluate the validity of the confidential provision at all. So this delineates the ways that defendants have misappropriated WFG's confidential information, including its hierarchy, confidential compensation structure, and customer lists, and how those actions have damaged WFG. Again, so I'm working for Coca-Cola. I go and I target their top clients, their top producers, their the way they bottle stuff, all of the information that I can gather while I'm there. I leave it on my living room table for my wife to have, and then she goes and uses it to be able to recruit the clients and the hierarchy, the people with the employees inside of that company, right? So that's kind of what they're talking about. They're saying that you can't just get rid of all of that because you're saying that it's a non-compete. WFG's hierarchy lists are explicit within the definition of the confidential information. While the court alluded at the temporary restraining order stage that the fact that WFG is organized as a hierarchical structure is not confidential, and as such, it doubted the confidential structure of WFG's hierarchy. So their Olson's side is saying, well, because they use a hierarchy structure, everybody knows that, so that's not confidential information. And what WFG is saying is, well, we're not saying that the hierarchy, like having a hierarchy, is confidential information, but having the names and phone numbers and the amount that these people make is confidential information. So they're separating the difference of those. It is the information within the hierarchy for which WFG claims confidentiality. So it's not the list of having a hierarchy or being able to have people in a hierarchy standard or format. It's what's within the hierarchy the information that's important. Specifically, it is the location of insurance agents, their relationship to other insurance agents within a particular hierarchy, information that is not listed on WFG's website or is generally known outside of WFG, and these are either rapidly apparent or readily accessible information to those within WFG as confidential. Defendants targeted insurance agents based upon their location in hierarchies, premise upon how moving to GFI would encourage or influence others in their upline or downline. So again, if I'm working on a guy, I work at Coca-Cola, and I'm working at one of the top producers there because I want him to move to my new company. Well, I go to his client, or in this case his team, and I say, hey, you should move over with us. We'll give you $1 million discount, whatever it might be I have to say to get them to move over. Well, now that guy that's going to stay at Coca-Cola is going to lose all of his income. So now he's kind of forced to come over if he wants to keep any of his income, or he stays there and Olson would pull all that into the new company. So defendants further misappropriated WFG's confidential hierarchy information in pursuit of the anchor leg strategy. When defendants met with spouses to enlist them into their scheme, they used their knowledge of confidential hierarchy information, including performance metrics, where each spouse was situated in the hierarchy, to determine which spouse to convince to join to GFI, and whom to encourage to continue working for, building up business at, and collecting compensation and confidential proprietary information inside of WFG. So these people are still working for the company and then moving stuff over into the new company. Defendants also shared their WFG confidential compensation information in violation of their confidentiality provision, in addition to GFI employees working at the behest of the Olsons sharing this confidential information. Defendants encouraged other WFG insurance agents and asked them for compensation compared information via social media, discussing DeJuan Cofield's Instagram story. Everybody is asking about the difference in compensation. Other defendants, including Cheranowski, provided compensation payment analysis, compared WFG's compensation model to GFI's compensation model. Further, GFI agents worked on behalf of defendants to make attempts to misappropriate confidential information by consumer information by downloading customer lists to bring them to GFI. For example, Valle, insurance agent working off behalf of GFI, and therefore the Olsons approached more junior WFG insurance agents, Lopez, and asked her to download and compile the customer list for various carriers for which he sold policies to at WFG, the purpose of bringing those lists with them to GFI. And so we've had a lot of conversations in the comment section, I appreciate, but a lot of GFI people were saying, oh, they're not churning, they're not pulling clients over. Well, I don't know. This, at least in theory or in allegation, is saying that they are doing that. At least one other WFG insurance agent reached out to Ms. Lopez to perform the same task. Case law supports and finds that confidential information includes information defining names, positions, salaries, employees, the allegations of poaching scheme predicated on the use of confidential information that lift the plaintiff's business wholesale to the benefit of or detriment constituted plausibly plead damages. So they're referring to another court case here. In this misuse of WFG confidential hierarchy, compensation, and consumer information that constituted a breach of confidentiality provision by defendants and has caused significant damage to WFG in the form of loss of large swaths of insurance agents, customers, and therefore its business. Somebody updated me, I think there are like 8,000 insurance agents now. Now, how many of those were former WFG? I don't know, obviously. I tried to at least ask to get a better idea of that. Well, how many of those are licensed? I haven't been able to get an answer. If anybody has an answer on that, that would be helpful for me. Because obviously if they have 8,000 agents and 100 of them are from WFG, okay, like not a big deal. But if they have 8,000 agents and 7,000 of them are from WFG, that's a much bigger difference on how many people are actually kind of moving over. So WFG has stated a breach of contract. WFG's non-disparagement provision requires that insurance agents do not do anything that will damage the business or good name or reputation of WFG. Although the court denied WFG's request for a temporary restraining order, Olson's breach of the non-disparagement provision, the court has not questioned its validity. So what we've seen from Olson's side a lot of times, they go, well, the temporary restraining order was denied So that means that the court has already found in my favor. And I saw a lot of posts about these. They're like, we won because they didn't get the temporary restraining order. The temporary restraining order just means that you can't go out and continue doing the things that you're doing. It's supposed to stop you from having that ability to go out and keep disparaging the company. And if you do, there's going to be even bigger penalties on that. So because WFG lost that doesn't mean that they lost the case, but that's kind of been Olson's position is, well, I didn't get the temporary restraining order because of the non-disparagement provision, so that means I've won the case, and basically we don't even need to abide by anything that the judge says around this non-disparagement agreement as far as turning over evidence or anything else. So in this line with California law, and they'll go through some more case, to state a claim for disparagement. So this is how they would have to actually file it, and thus a breach of disparagement clause. A plaintiff must allege a false and misleading statement that, one, specifically refers to the plaintiff's product or business, and two, clearly degrades the product or the business. So the question is, did they meet that standard? Did they say something that specifically refers to a product or a business, and did they say it in a way that is derogatory towards that product or business? And I think most people would probably agree with that. So WFG has pled those elements. A plaintiff need not to allege the exact words or circumstances so long that is alleged that the substance of the defamatory statement. So they don't have to know the exact words that were said. They just need to know the overarching, this is why it goes into intent of what was being said. Defendants told innumerable lies to WFG insurance agents to encourage them to leave WFG and join GFI. And those lies that disparage WFG and therefore breach the non-disparagement clause fall within two main categories. First is going to be insurance agents' income and their ownership of their stream of income. And this is still happening. I'm still seeing them talk about this. And I haven't seen in their contracts, I have the contracts on our site. You can go look at those if you want to see GFI's contracts. I don't see how they're different in any capacity of their ownership, other than Olson may have offered ownership to some of the people, but he couldn't have offered it to 8,000 people if he's going to give everybody a percentage, right? So the second of that is the survival of WFG. So if you think the ship is sinking and your options are to stay on the ship and drown or move to the lifeboat, well, obviously you're going to move to the lifeboat, right? Like that's just common sense in human nature. So that's what they're saying is, if they're saying that WFG is falling apart and they trust in Eric, they believe in him, he's been in the company a long time, he's saying things that are happening maybe behind the scenes, well, they have reason to believe that. So statements in these categories specifically refer to WFG's business and degrade the business and its determinant of WFG agents, putting it squarely in the non-disparagement provision. The ownership of the insurance agent's income stream, known as their code number, and the availability of that code number to transfer to insurance agent spouse upon death is particularly significant issue at WFG, where many insurance agents work alongside their spouses and their other family members. It's one of my favorite parts about the industry, is being able to work with your family members, and that's absolutely right. So that's a huge selling point in our industry if there's misdeeds happening with that. Defendants represented falsely that to WFG insurance agents that if they remained at WFG, their code would not transfer to their spouse upon death, where as strong but false incentive to switch to GFI. This lie was promulgated heavily by defendants, including Cofield, spreading such a lie on social media. We watched those videos. I have those on the YouTube channel as well, telling insurance agents that that lie during separate in-person recruiting meetings. In the defendant Cofield's case, he told a story where a particular widow on social media was left without her husband's code after he suddenly had passed away. This lie so upset the spouse that she posted on her own YouTube video claiming the defendant's statements were inaccurate, and she was pleased with the way WFG had handled her business after her husband had passed. Defendants also spread lies disparaging WFGs related to income and earning of insurance agents. For example, Cofield posted on his GroupMe chats with hundreds of insurance agents that if WFG Insurance did not go with us now, they would go back to their $50,000 watch. In another example, defendant Olson told WFG Insurance agents that Maricela and Rivera that WFG was restructuring its commission and depriving insurance agents of income. This, along with other lies of the defendant Eric Olson, told the Riveras that enough to convince Rivera to leave WFG and go to GFI until she did further research and realized that she had made a mistake. She registered with WFG as soon as she realized her error and based on her defendant's deception. I'm working on getting an interview with her too, so hopefully we'll be able to have her on and kind of see exactly what was said. Defendants also lied to WFG insurance agent about the survival of WFG and its business, in particular high-level WFG field leaders and home office executives who were planning to leave, whose departures would allegedly spell the end of WFG. These misrepresentations about WFG business were derogatory, suggested that it was unable to retain highly respected individuals such that others would be manipulated into leaving. For example, during a in-person recruiting meeting, this is the testimony of Bosley and Day, Carlos Riviera, that Thawley, the chairman counsel and influential within WFG, would be leaving to go to GFI. It wouldn't be funny, but it would kind of be funny if that ended up being true, but that would not be good for WFG. This is blatantly untrue, and upon learning of these false rumors, Mr. Thawley participated in a meeting with WFG insurance agents and employees on the 17th to dispel these rumors. Cofield told the same lies about Thawley to Nathan Shadrack, and so we have that testimony as well. Defendants Eric Olson told Bosley that Susan Davies, WFG Senior Vice President of Field Relationships and Supervision, and the head of WFG Foundation, was leaving to join them as well. The Olsons argue that WFG, that's a new one to me, I didn't hear that one before. So that must have come out maybe in a little bit of discovery. Olsons argue that WFG failed to plead special damages in relation to its breach of contract claim related to the non-disparagement clause. At first, it's important to note the facts of this action are evolving daily, so naming particular insurance agents have left WFG as the date of the particular filing. It is a challenge, or it is challenging as if not impossible endeavor. The same reason applies for WFG's loss of customers, loss of revenue, damages, and other harm that WFG continues to face due to the defendant's disparagement. Disparagement statements such as other lies as people leaving also create blood in the water, right? If you think about a shark, right, it kind of is a feeding frenzy where falsely misrepresentations lead people to think someone is leaving, so they leave, then customers or those in the market learn about the exodus, so then more people leave, which cause further harm to the company. WFG has, as the time of the filing, pled special damages to encapsulate the harm it has endured as best as it can currently, and without the benefit of expedited discovery that defendants continue to drag along. The disparaging statements the defendants made to WFG insurance agents were directly harmful to WFG and constitute a breach of the non-disparagement agreement. WFG has stated breach of contract in violation of non-solicitation provision, although the Olsons assert that the court already found the non-solicitation provision void. In the temporary restraining order did no such thing. So again, just because you don't get a temporary restraining order, you don't get a movement, doesn't mean that you win the case. And that was kind of their take of it early on, and it continues to be their take on it, in that even in the discovery phase, when WFG was requesting stuff around the solicitation aspect, they're like, well, no, we already won this. We don't have to give you anything around us soliciting people because we've won that part of the case. And it's like, no, that's not actually accurate. WFG has not shown that it is likely to prevail on the merits, is what it said in the temporary restraining order. So not likely to prevail doesn't mean you have not prevailed, right? So very, very different. This determination had no bearing on whether the non-solicitation provision is void or not. They're just saying at that time they didn't have enough merits to actually reduce his First Amendment rights. The court simply ruled that, again, the temporary restraining order junction in analyzing the restrictive covenant of employee context. So difference if you're an employee versus if you're a business partner, different on how those things are handled. The motion devotes many pages to Edwards' analysis, but the Olsons miss the point. Edwards' holding and the Edwards holding and analysis only govern post-termination activity when reviewing the enforceability of restrictive covenants. It does not void the covenant not to solicit while the worker is still engaged with the company. So big difference there, right? Like, yeah, if you're no longer working with the company, there might be an excuse potentially to be able to go and solicit or whatever you need to do during your job, during performing your business. And I think most people would be okay with that, right? Like, Olson moved over and his wife moved. Would you say that that's solicitation? Well, no, probably they're going to move together. If you were to bring over some of the people that were close to you, they would probably come over. There probably wouldn't be a lawsuit about that. We understand, or WFG or the industry would understand that that's probably going to happen. I've had guys leave, right? And so I expect their guys to go with them. That's just kind of an understandable thing. Didn't do a lawsuit about it or anything like that, because you kind of expect that to happen. We talk about ownership, but there is kind of a little bit of that in that people want to follow certain people, and that's perfectly fine. So holding that this particular section, the section 16600, take another shot, does not void an agreement to solicit while the individual is still under contract. And this is why Olson's kind of playing a little bit of that game of like, okay, well, we'll comply with giving you the discovery after I left, because I can poach people after I leave, because now we're in competing businesses and now it kind of becomes a fair game. So we'll give you the documents, the text messages, and the emails after I've left, because it won't matter under this, because now it becomes two businesses competing. And what WFG is saying is that's not true at all. You're still obligated to these things while you're with WFG. So you went and created another company. You're moving people over while you're still with us, and you're moving people to GFI. That's totally different. That's solicitation while you're still with the company. That's different than doing it after you've moved to the other company. So here WFG alleges the defendants engage in both pre and post termination actions that violated non-solicitation provision. With respect to the latter, WFG reserves its right to distinguish Edwards, this particular case, versus healthcare, and its progeny in the expedited discovery and evidence that preliminary injunction hearing so permits. So as a defendant's pre-termination misconduct that violated the non-solicitation provision, they plead that sufficient facts demonstrate that they breached this enforceable contract. WFG terminated Olson's contract for cause on January 22nd and for this exact thing, because it looks like they caught him doing this exact thing that they're talking about. So to set that line in the sand and say, well, we'll only look at his actions after he was terminated is very, very different of what led up to the termination. So defendant Olson's recruited Riviera and her husband early in November. Oh, 28th, wow. Okay, so that was all the way back in November. That's right. So, which included, among other things, an NDA to shield his misconduct to recruit Riviera to GFI, all well as lies that disparaged WFG. Not too long after and before WFG's termination of Eric for cause, he similarly organized and engaged in the same misconduct with Bosley on January 3rd. So again, this is important because this happened before the termination. So again, we're looking for cause, like what actually happened and why did it happen, to see the overarching aspect of what's happening. Is it simply just a guy who wanted to go start another company and he's just trying to create his business and grow his business? Or is it somebody who's actually stealing from one company for the benefit of his company? And again, before his termination with WFG, defendant Olson attempted to recruit Rob Day, McGinnis, and the same tactics as Riviera and Bosley. Each of these factual allegations must be taken as true, demonstrate the defendant Olson's direct violation of the non-solicitation provision. WFG, through its own investigation, became aware that the defendant Sandra Olson was involved in planning the creation of GFI for approximately 3 years, and we have this testimony from her. She basically said that in a Zoom call, which we'll talk about here in a second, where she said that they've been working on building GFI for 3 years now, that this wasn't something that just happened overnight. They've been planning it for a long time, and So they've apparently been doing this, they've been thinking about or have been working on this for a long, long time. WFG contends that she was likely involved in the recruitment prior to her resignation of WFG, but requires further discovery that the court has granted, but with which Sandra Olson has not yet complied, to understand the manner of the scope of her involvement. And again, the reason why, at least in my opinion, why they're delaying this is because if they can get to the dismissal before any real evidence comes out, then they go, well, this is all just hearsay. Yeah, a couple people said this, a couple people said that. We have some people on our side, they have some people on their side, but no text messages or emails went out. Well, it's a lot easier to win this dismissal case than if you have a mountain of evidence of what you were doing beforehand. The non-solicitation provision does not only make direct solicitation a violation of the agreement, but it also prohibits indirect solicitation while still engaged with WFG. This equally plaids facts sufficient to demonstrate that the defendant Eric Olson breached the non-solicitation provision indirectly by orchestrating his co-conspirators to do his bidding before his agreement with WFG ended. Furthermore, this particular section 16600, take another shot, decision did not apply to defendants who were working and recruiting WFG insurance agents outside of California. So that becomes another good question too. If you were recruited in Texas or Florida and you're taking the advice from them to do these exact things in California, does that California law still protect you or no? So that's going to be an interesting aspect as well. This is where the agents get hurt more than the people who actually do all of the main stuff. So defendant Carter lives and works, at least to some extent, in Nevada. I didn't know that. Cherwanowski lives and works in Florida. Their actions in violation and the non-provision outside of California are breach of contract regardless of whether they happened before or they left WFG. So that's an interesting question too. If you don't live in California or work in California, does that law still protect you that you can do all the stuff that you want to do just because California says it's okay? The foregoing allegations are sufficient to state a viable claim for breach of contract on the premise of non-solicitation. Notable, contains sufficient facts to state tortious interference claim, rests on numerous independent wrongful acts. Number one, a valid contract between the plaintiff and the party was in place. Number two, the defendant's knowledge of this contract. Number three, the defendant's intentional acts designed to induce, breach, or disrupt the contractual relationship. And four, actual breach or disruption of the contractual relationship. And five, resulting damages. So they meet all of the qualifications for what they're saying in tortious interference because they meet each one of these five different aspects to be able to meet the threshold of that. All WFG relationships and its insurance agents and customers are by contract. Defendants have acknowledged of that. They've worked with the company over 20 years. They have 900 insurance agents with identical, similar agreements. So they've even helped people sign these contracts in ways that the defense intentionally and deliberately breached their amendment agreements. So again, it goes into intent. Was this something where they just didn't know any better? And they recruited mom over, and now WFG is just like over enforcing these laws and saying, hey, I know your mom worked with you, but she was formerly with us, and so you're not allowed to recruit her over, and so we're going to sue you because you brought your mom over to your new company. Or did they have ongoing knowledge about these things that they weren't supposed to be doing it? Were they hiding it? Were they trying to protect themselves in different ways, knowingly breaking the contract? Is very, very different than, oops, I just didn't know I couldn't do that. Caused other insurance agents to breach the same provisions and cancel their agreements in full. It's alleged that recounted in Supra, and they're going to go in through some more case law. In the Ninth Circuit, affirmed that the court's finding and the plaintiffs failed to allege that the defendant accepted a contract with a third party with the intent to breach an existing contract. So there's a difference between taking a new contract and purposefully breaching your contract. By contrast, WFG expressly makes those allegations here. Defendants intentionally disregarded their own contractual obligations, and they encouraged other WFG insurance agents to breach their own contractual obligations and resign WFG to join GFI. Additionally, unlike it in this particular case, describes the nature of WFG's business and the resulting disruption of defendant's actions to cause to its economic relationships. Tortious interference claim must survive. Factual allegations that show the defendants orchestrated and participated in a civil conspiracy. Has alleged the breach of contract claim premise on numerous provisions in its proffered viable claim and civil conspiracy, particularly in its detailed description of the defendant's anchor leg scheme. So again, and what we'll see a little bit in Olson's is how do they try to protect themselves. So the anchor leg scheme is showing that it's a civil conspiracy, right? Like they knew what they were doing, but they intentionally tried to find ways around the system. And they got other people to do the same exact thing. The motion's only basis for dismissal is on the erroneous assertion that WFG has not stated a claim for breach of contract and fraud. However, this makes it plausible allegations with particular and specific regarding overt actions the defendants and their co-conspirators took to push the anchor leg strategy scheme forward to benefit themselves, co-conspirators, and GFI, and to harm WFG. So again, why do that? If you're accidentally breaching the contract, why not just move over? You have some people come over with you. That's perfectly fine. The difference is, are you intentionally trying to hide what you're doing? And that's what they're alleging the anchor leg scheme does, that you're staying with one company and then you're moving stuff to the other company simultaneously, so you know what you're doing. You have intent behind it, versus I just went to a new company, some people decided to follow me. They're two entirely different situations. The outcome is the same and the 1,000-foot view is the same, but how and why it happened is very, very different. So defendants formed and recruited GFI, for GFI to compete with WFG in late 2003. As part of the conspiracy, Olson took steps to register GFI to do business in states with significant portion of Olson's downline insurance agents resided and participated in, including filing various registration application forms in California on October 18th, November 13th for Texas, Mississippi in November, Florida on the 21st of November. Each of these registrations occurred before WFG's termination of Eric Olson for cause. Defendants utilizing the anchor leg scheme to recruit away WFG insurance agents married couples to GFI, while one spouse remained at WFG, mirroring the overt acts the Olsons have already begun. Co-conspirators such as Jaronowski, Carter, defendants' conspiracy to further their anchor leg scheme. Defendants of their co-conspirators targeted WFG insurance agents, married couple under the non-disclosure agreement. They had them sign firewalls. So again, are they accidentally breaking the contract, or do they know they're breaking the contract and trying to protect themselves? They're having people sign firewalls. They're using self-deleting messaging applications. They're to officiate their recruitment under the scheme and avoid detection and scrutiny. During recruiting meetings, defendants and their co-conspirators spread lies about the financial viability and the GFI is being more lucrative, but false promises, among other lies, to entice WFG insurance agents to leave for GFI under the anchor leg strategy. These allegations at minimum show that there was formation of operation of conspiracy and damage resulting from the plaintiff and their acts, a furtherance of the common design. WFG satisfies the 9B rule for heightened pleading standards, bringing a fraud claim. The goal of pleading fraud with specific giving defendants notice of a particular misconduct so that they can defend themselves against the charge, so they're saying that they've done this correctly. So to meet that standard, where's step one? You must have misrepresentation, knowledge of falsity or concealment, intent to defraud, to induce reliance, justifiable reliance, and it must result in damages. Defendants ignore the facts and plead to contend WFG's fraud claim does not identify the speaker of false statements, how such statements could be attributed to the defendants, or identify a time, place, or specific content of the false statement. The speaker of the false statement is any target of WFG insurance agent engaged in the anchor leg strategy who represents WFG in words or actions fraudulently and they remained loyal to WFG while they were making plans to follow their spouse to GFI, including the Olsons. Indeed, the Olsons are the original perpetrators and ringleaders of the anchor leg strategy, according to the defendants. Olson presentation on Zoom, GFI company or overview that's been in the making for 3 years. We'll look at that in just a second. Does it have the full one? Nope. Yet the defendant, Sandra, signed her most recent annual renewal of her agreement back in April of 2023. Olson signed his in February of 2023. The Olsons made representations to WFG through their agreement that they would not violate their terms and agreements, but yet they've been saying that they've been conspiring to do this for 3 years. While WFG is still investigating and uncovering which of its insurance agents fall within the scheme and has accounted for such wrongdoers in its DOE defendants, which they kind of fill out as they get them, and that's why Chernowski was added, Carter was added, Cofield was added. Describe multiple defendants who are alleged to engage in precise and the same contact, so they're still adding them. That's where discovery will help. Once they get discovery, they'll know who more of the co-conspirators are. The false statements made by these speakers include, at the very least, the affirmation representation made by the agreements signed by the targets after they were or intended to become involved in the anchor leg scheme. Through its independent investigation and discovery, WFG is continuing to uncover new facts related to the fraudulent conduct of the anchor leg scheme and the Olsons' long-laid plan to raid WFG. Should the court find deficiencies in WFG's allegations of fraud under this particular rule, which it should not, WFG should be granted to leave amending its plea. So if you find that this is inaccurate, allow us the ability to adjust some of these things. Competition and the unfair competition law, defendants spread false lies, damaging information of insurance agents leaving. They're kind of just repeating a lot of stuff and having it qualify into these again. WFG has adequately alleged its unfair competition claims. The conversion claims is sufficiently pled and is not predempted. Defendants obtained WFG's confidential business information through the course of their engagement. They wrongfully leveraged this information in their business to target high-earning insurance agents, entice them to join the defendant's new business. So they're kind of just reiterating a lot of this stuff for each one of these points. WFG does not plead a trade secret claim to that of the confidential information, which was converted, constitute trade secrets. Further, a motion to dismiss based on the preemption cannot be addressed until it is determined whether the alleged misappropriated information constitutes a trade secret. So we want a ruling on this before we just get rid of the whole thing. WFG has properly pled a claim for conversion. The elements of these conversions, California law. Number 1, did the plaintiff's ownership or right to possess of the personal property, did they have a right to have it? Number 2, does the defendant's disposition of the property in a manner that is inconsistent with the plaintiff's property rights? And does it result in damages? And if they met those, then we feel that they feel that they've done that. Defendants or those acting as co-conspirators of defendants use those materials inconsistently with WFG's rights, and furthermore, the revenue and market share, as well as devaluing confidential business information in the form of loss insurance agents, customers, and therefore their revenue. So by them doing this, it's causing us harm. It adequately pleads an unjust enrichment. They're going to go through same thing. Confidential business information, it's unjustly enriched their lives. Leave to amend is appropriate. So judge, if you don't like any of these particular things, allow us to amend it and change it to where, right, we're being a little bit broad here because we're still in discovery. We're still trying to figure these things out. We're willing to amend these and make changes, but we still feel that it's valid. So in conclusion, for the reasons stated above, we respectfully request that the court deny the defendant's motions to dismiss. And if you do, leave it to us to be able to amend it, make some changes. So if you don't like one thing, don't dismiss the whole thing. Allow us to come in there and change it. So that's WFG's side of it. That's their feelings about it. And makes logical sense, seems to make sense to me. It's kind of similar to the things that we've been talking about and kind of our feelings about it, or at least mine. I don't know how you guys feel about it, but let's kind of look at this one. So they had alleged Sandra Olson has been talking that they've been doing this for 3 years. And I know we're running long today, but we got some good information to go over. So Sandra Olson has basically came out and said that she's been planning this for 3 years. So this was apparently on a Zoom call of theirs. So some kind of recording here on March 28th. And so in her Zoom call, she's saying that this is her exactly what she said. So I don't know how they got a recording of this, if somebody was in there, but basically Olson said, we're super excited of just all the greatness. Honestly, I really am. It's been 3 years in the making. 3 years, it wasn't like I woke up one day and I just was like, that's it, right? No, it's been 3 years in the making. It's not necessarily, I can't even say it just started. This has been it for many years, right? A lot of us come from the industry. It's not a startup. Don't ever think of it as a startup. There's so much knowledge of so many years. We're not starting from square one. We're ahead. We're literally ahead of the game in so many different aspects. You see it in those of you who are brand new. You'll see it through the course of you being with us, and it kind of carries on. So the question is, were they planning this for 3 years? Is that her testimony here? That they had planned for 3 years to actually start their own company? I don't know. It's kind of what she's alleging here. Big question mark on that. So I guess we'll have to see. I don't know. I mean, it certainly feels like they had some kind of plan. I'm guessing that's why WFG was a little bit skeptical about letting them do the transfer of ownership from one spouse to the other. So I don't know. Makes it kind of an interesting topic to talk about. I guess we'll see. So next, let's get into what GFI's response is, or their reply is the correct term, to WFG's response, and we'll kind of see how you guys feel about that, and you guys can determine which one you feel has a stronger case kind of moving forward. So we'll move in.